Thank you very much, Kate, for the invitation and the lengthy introduction. And thanks everybody for joining. It's my first time in Ann Arbor, so it's been really nice just sort of getting to see the town a little bit. And so I'm here to talk about guns, but the intersection between guns and reproductive justice. So going to be bouncing around a little bit, but hopefully by the end, it'll make some sense as to sort of the connection, at least that I see, between these two things. So we're going to be talking a little bit about rights and government authority to begin with. And, I figure since not everybody here may be familiar with the law, do a little sort of intro, because I think it's really important for a lot of the things that I'm going to be discussing. Then I'll go into the most recent Supreme Court ruling on the Second Amendment, which is Bruin, talk a little bit about Dobbs. My understanding is that people here pretty much know Dobbs, so I'm not going to talk about that too much. And then sort of the intersection between these, again, thinking about the reproductive justice movement is something I've done a lot, and what that tells us about other areas of law and sort of the exercise of rights generally. And then I'm going to talk about the current Second Amendment case that's at the Supreme Court, which is Rahimi. They've already had oral argument. A decision will come out sometime in the next few months, but probably not until June. Okay, so let's go back to 1803. I'm sure Kate remembers this fondly, Marbury versus Madison. And the most important part that I want to sort of instill here is, early in the country's founding, or after the founding, was this question of what is the role of the courts vis-a-vis the legislature, right? And part of the issue in this case that the court says is, look, the government is a government of limited powers, right? And so part of that then is the government can't decide what restricts their powers and what doesn't, right? And so rights, constitutional rights being the one thing that they're sort of talking about here, that the Supreme Court then, the judiciary has to be the ones that decide what the rights are, because the rights in the United States, the way that we have them in terms of the Constitution is they're what's referred to as negative rights. So they restrict government action as opposed to positive rights, which are thought to require the government to do something. And so a lot of these early cases then are about, what's the government's role? What can they do? What does the judiciary do? And sort of how do we think about rights? So police power is not anything to do with the police, but the states have this broad authority to pass laws that's referred to as the police power. But basically it says, the states have the ability to pass laws for health, safety, and welfare, right? Protecting the public, essentially. And so that's really, really broad in terms of what they can do, as opposed to the federal government, which mainly has to do with regulating interstate commerce. And I'm not going to go into the Commerce Clause as much as that would be super fun to talk about the Dormant Commerce Clause. So we're really going to be focused on police power because it's a lot more broad. Now, again, though it's broad, right, rights are the things that restrict what the government can do, right? And so the government can't just do whatever it wants whenever it wants to do it. So then again, thinking about, can the government do this, or is there a right that is a barrier to it? So then we're going to fast forward a little bit to 1905. There's this case, Jacobson v. Massachusetts, which nobody cared about except for public health law people like myself until COVID came about. But the essence of what's here, and I know it's a lot of words, which is the thing that I always tell my students not to do on slides, but words are what matter in terms of the law, so I kind of can't help it. But again, the important parts of this is the Supreme Court in this case says rights aren't absolute, right? The way that organized society works is that all rights can be limited, restricted to some extent in some situations, right? For the benefit and protection of others. And so at a very basic level, right, organized society is about, we're not running around in the jungle, everybody just sort of doing whatever they want anymore. We are sacrificing some rights in certain circumstances because we know that the government's going to, at least in theory, protect us, right? And do what is best for us. And so that's really kind of the broader emphasis of what the court is getting at in this case. And so one of the things that they talk about is, yes, police power, it's broad, health, safety, welfare, because this is a case about smallpox and smallpox vaccinations. But at the same time, I think, courts have a role too. And so if the government is doing something that is arbitrary or overly oppressive, right, they're sort of going too far in limiting rights, that's really where the court can step in and limit what the government is doing. Okay, so that's the sort of setup for moving into, now we're fast forwarding another century into the Second Amendment. And so when the Second Amendment comes about in the Heller case, the big question here that the court was trying to answer is there an individual right that comes from the Second Amendment? And ultimately, they say that there is. The right is based in sort of the pre-existing right of self-defense. And so you have a right to defend yourself. And what happened at the founding was they said, we're going to enshrine that right with keep and bear arms in the Second Amendment. And so they said, we're not really getting into the full scope of what the Second Amendment means and doesn't mean. We're just saying it's an individual right. And in particular, in that case, there was a question of, can you have an operable handgun at home to use for self-defense? The court says yes. And the court basically says, any way that we would think about, look at this, analyze it, this is invalid in terms of this individual right. And so they don't really give a lot of guidance then to, well, how do we think of any and all other gun-related safety measures, right? And in particular, because they're trying to figure out what does the Second Amendment mean? Is it individual? Is it militia? What does it protect? It's a lot of history, right? It's a lot of before the founding, around the founding up through the 14th Amendment and Reconstruction. And so it's very historically focused. And so coming out of that, there was this question of, well, how do we think about, or how should courts analyze other challenges to gun laws? So then we get to Bruin, right? There's another case in between at the Supreme Court, McDonald, but that really was just saying, this is a fundamental right and it's held against the states as well. So we're not going to get into that. So then the court just sort of leaves everything to the lower court, or the Supreme Court leaves everything to the lower courts, after Heller, essentially. And the lower courts are trying to figure out, and again, wrestle with how do we evaluate these laws, right? And so a lot of challenges come about. And frankly, for the most part, the gun laws are upheld. Right? And the reason being, a lot of times the courts are saying, look, yes, this is an individual right. The Supreme Court has said that, but gun violence is a problem. And so your Second Amendment individual right can be limited in certain circumstances, right? When the government is trying to tackle and mitigate the impact of gun violence, right? And so it's this balance. And this, for the most part, generally speaking, is how constitutional law works. Right? Think about what's the government doing, why are they doing it, how are they going about doing it, and then the right on the other side. How is it burdened? How much? How important is that right? And that's how we sort of evaluate it. We get to Bruin, and the Supreme Court says, no, we don't like that. That's not how it should be done, right? And so here they say history is really the thing that's going to tell us whether a modern gun law is constitutionally valid or not, right? Okay, so the law at issue in Bruin is what's called a proper cause or a good cause law. And so this is about, can you carry a gun out in public, right? So again, Heller is really about the home. And so there's this question of, does the right extend out into the home? And there are some lower court cases where they say, look, if you can defend yourself at home, you would need to defend yourself potentially in public, so it doesn't make sense that it would be restricted there. But so there's a law in New York that says, if you want to carry a gun in public, you have to get a permit. To get a permit, you have to show that you have some need to have a gun on you in public. And you can't just say, well, in case something comes about, right? There has to be some tangible reason. I have gotten attacked before. I live in a dangerous neighborhood. I have a dangerous job. I have a stalker, right? Any of these things could potentially be used. And so in this sense, you could see what New York is doing is trying to find that balance, right? We're worried about gun violence, so we don't want any and everybody carrying guns in public, but there's a right to self-defense. So we don't want to say nobody can have one either. So the people that have a specific reason to think they might need to defend themselves in a public setting, they'll be the ones who can get a firearm. And again, what the court could have done is say, you're being too strict with this, or you're, being discriminatory, you're allowing some people and not other people. But instead they said, no, we're going to strike the law down completely because the only gun laws that are allowed are ones that are similar to historic laws that existed from the founding up through the Civil War and Reconstruction-ish, right? So the court says there have to be similar laws. They don't have to be identical, but they have to be similar enough. Not sure what that means. It has to exist in enough places, jurisdictions, states. They don't really say how much is enough, because there are historic laws that actually are pretty much identical to the one that's being challenged. And they say, yeah, but that's like 1 or 2 states. That's not really sufficient. And then say, well, here are some in these other areas. And they said, well, those are more territories at the time, so those don't really count. Well, here's some in other places. Well, those really weren't very populated, so it didn't cover that many people. And so what the court is doing is saying, here are reasons to strike down laws, but they don't really say, here's how you uphold modern gun laws, right? And so then this question becomes, right? And so again, so they say, this law is invalid because, there's not enough sort of historical support. So now moving forward, right, there's this question of, well, how do we think about gun laws now? And essentially the court is saying it's all history. You have to find historical analogs that you can point to, and they have to be similar in the sense that they are, comparable in the terms of the burden that it places on your Second Amendment right, and the reason, right, that it's being passed, right? So the justification has to be similar. Okay, so the other thing, actually, before I move on, is what this means is, right, again, before it was, all right, so here's the right, how is it burdened? But let's think about gun violence and, is this going to mitigate it or in some way? Here, the court, they don't talk about gun violence rates. They don't talk about, how effective is this law? Does it actually do anything or not? None of that stuff matters, right? And in fact, in his concurrence, Justice Alito criticizes the dissent for talking about this stuff, right? And one thing he says, why is the dissent talking about mass shootings? Like, well, why does that matter? Who cares about that, right? That's not what this is about, right? So what we have here is sort of, a focus on the right itself. Is there a right to carry in public? Yes. Is there some historical law that's similar? No, that's the end of it, right? Why the government is doing it doesn't matter. So then if we look at Dobbs, which again, I'm not going to go through the details, it's the opposite, right? So it's all historical. It's all, we go back through history. Is there a right to abortion? No. So basically the government can do whatever it wants, essentially, right? And so here what we're seeing is the court is increasingly focused on the right, as opposed to what is the government doing and why are they doing it? And hopefully by the end, you'll agree that that is problematic, because when we're thinking about just the rights, whose rights are protected, what type of rights are protected is really important. And again, this is something that the reproductive justice movement really sort of focused on. So when we're thinking about Dobbs, right? Again, there is, I think the majority opinion is like 87 pages, right, of history, essentially. They say there's no right. Now, again, the government, just because you don't have a fundamental constitutional right, that doesn't mean the government can do whatever it wants. Again, right, it's supposed to be, okay, well, you're passing a law to protect public health, safety, or welfare in some way, right? It has to connect to the thing that we empowered the government for in the first place. So here, right, there's this question of, well, what is Mississippi doing and why are they doing it? And essentially there are, well, let me actually go back, like this is the full application, right? So in 87 pages, when they get to what's Mississippi doing, is it valid? You have basically 2 sentences, right? That are like, Mississippi legislature has a problem with this and they think that it's good to change it to 15 weeks. Fine, right? So there's no examination of how's Mississippi doing in terms of these things they say they care about, like safety of pregnant women. Well, they're terrible in terms of maternal mortality. Well, what about this, potential life of the fetus, right? They're also dead last in infant mortality, right? None of this is in the opinion. Right? So again, the court is not concerned with, is the government infringing on reproductive autonomy for some purpose, to gain something, to protect something? The potential life and fetuses, that's all that matters. Whatever else Mississippi does or doesn't do is irrelevant to the court, right? So thinking about, reproductive justice, after Roe, part of this came about because really there, again, was this really narrow focus on the right. We have a right to abortion. Great, right? But Black women were saying, yeah, the right exists on paper, but who can exercise that right? Who has the choice, right? What does this mean for people that are criminalized, that are impoverished, that are underpaid, right? Those things all have an impact on whether they actually have the ability, the autonomy to choose whether to have an abortion or not. But importantly, it really wasn't just about abortion, right? Loretta Ross talks about this and says, it's about all reproductive choices, right? I want to have a baby. I don't want to have a baby. I want to raise a family. I want to raise it this way. When and how you want to do it, and the ability to make those choices is really what the movement was kind of focused on, right? Okay, so now we're gonna backtrack again. Let's get back to guns a little bit. So we go to the Bruin decision, say, yes, you have a right to carry guns in public. So what does this mean just in terms of public health and outcomes? And this is just one representation. There's plenty of other studies, but basically, the data and the research suggests that the more lax laws are for carrying guns in public, it's an increase in crime and increase in violence, right? So gun deaths, if we look at that, suicide was typically about 60% of gun deaths, and homicides were the rest, give or take. But as you can see, homicides are increasing, right? And so that gap has been closing over time. And there are racial disparities in terms of gun violence. And those, as gun violence is increasing, gun deaths are increasing, that gap, that racial disparity is also getting wider over time, right? So who's going to be most impacted by these expanding Second Amendment rights, more guns in public, right? You can see here, Black people are the ones, but people of color, communities of colors tend to suffer the most, right? You can see Black men in particular are most at risk. And so, there's just a lot of data to show how problematic this is. And so as the court is saying, more guns is fine, right? There's a right that needs to be protected. And again, not looking at how does this play out in real life, in the real world, right? You can see the risks of increased guns and increased guns in public is not shared equitably, right? So what happens if gun violence starts to spike, right? More people are carrying guns. Again, the data shows that then there tends to be more gun violence and more crime. We could have increased policing. Well, how does that play out, right? You can see here, right, when police are responding to areas that have higher percentages of persons of color, there's a greater increase that they will use force, right? And so again, right, not only the potential for, gun violence in general, but the response to gun violence also is problematic in terms of what can happen. So then we think about, okay, well, let's step back and look at, who wants to then carry a gun and what does that mean, and the ability to, as the Supreme Court says, defend yourself should you need to, right? And so this is Philando Castile. He got pulled over. He told the officer, I have a gun. I have a gun that I cannot reach. I can't access, as well as a permit that says that I illegally can have it, right? He gets shot and killed. Right here we have Kyle Rittenhouse, arguably illegally has a gun, crosses into a different state, walks into protest, and sort of marches around with an AR-15, or at least something equivalent to it, saying, I'm going to protect this community, right, in the way that I think I can and should. Ultimately ends up shooting and killing. Someone goes on trial and they say, he was defending himself, right? If we look at this, so this is John Crawford III. He is in a Walmart, and another customer calls the police and says, there's a man in here with a gun, right? So the police come in. There's video you can see, but I wouldn't necessarily recommend it. They come around and instantly, as soon as they see him, they shoot him. Well, he's holding a pellet gun that was for sale in the Walmart, right? as opposed to, this is Dmitry Andreychenko, after there was a shooting in El Paso, Texas in a Walmart. He in Missouri said, well, I want to make sure that Walmart is, respecting my Second Amendment rights. So I'm going to arm myself up and march into this Walmart and see what happens. The police are called, but as you can see here, it's a much calmer response in terms of, trying to figure out what's he doing? Why does he have these, weapons? And so there's two problems here then, right? One, again, is police response. How are the police going to think about and handle people that are armed in public at an increasing rate, right? And so this idea of who can exercise those Second Amendment rights, it's not equitable, right? And again, you look at police shootings of black males, almost universally, right, they are found not guilty and ultimately get to go. But if we think about, right, these other people that are arming themselves in public, how are we, the public community, going to be thinking about this, right? How are we going to be thinking about who's armed, who's not, who's in a Walmart exercising their Second Amendment rights versus who's in there about to, start a mass shooting, right? We're not really great at making those predictions in terms of who's likely to do that or not, right? And so we're going to start thinking about it through other lenses, right? Our biases of who's a danger, who is a threat, and who is not. Right, and so part of the problem in the Bruin opinion, Justice Alito writes this concurrence, and the language here is like, this is what we should have, right? Police can't protect everybody, right? So we should be arming ourselves, right? Let's go back to the founding era. There weren't even police. Police were created basically to track down slaves. He leaves that part out, actually, right? And so, there's this encouragement of this is the way it's supposed to be, right? Arm yourself, and you need to protect yourself, your loved ones, your community, your property, whatever. Right, so how does that play out? This is Ahmaud Arbery, right? And so he is on a jog, he walks around, to a house, the people come in, people see him and say, this is a crime that's happening, right? And so they go, and then an altercation starts. And importantly, part of the defense, ultimately they were found guilty. That doesn't, bring Ahmaud Arbery back to life. But part of their defense was, well, he started to come after us, right? Once we confronted him. And this also came up in the Kyle Rittenhouse case. And so there's this question also of, well, if you confront somebody and then you cause a confrontation and then you use the gun because of the confrontation you caused, does that then still qualify as a valid use of self-defense? And again, they were found guilty, but ultimately the point is still that they felt empowered to go out and figure who is committing crime, right? And so there's this, issue of vigilantism, right? People saying now it's my job not only to protect myself, but potentially, right, others and my community, right, if crime's going to happen. So think about, now let's bring it back, right? We'll sort of tie in Dobbs, right? So SB 8 that happens, right? Which is about literally people. You go and you can bring charges and sue people that you think are either, helping other people potentially get an abortion. Well, what if what you think is people are going to be, driving across state lines to go somewhere else and potentially murder this unborn human life, right? In violation of a law, right? Can you shoot them? Can you stop them with a gun, right? These things are a little bit unclear, but again, the language that the court is using and the way that they're encouraging this is very much a, look, guns are for you to protect yourself and those that you think are important. And they're also talking about human life, and fetuses are human lives, and that's why that right is so different, because it's about destroying a human life, right? This is the language from Dobbs. So as we start to think about these potentially increased confrontations in a public setting, right? How should we think about those? So this is the map for a lot of states have stand your ground laws, right? Which say if you are in a place legally and you feel threatened, you do not have to retreat, right? You can use force up to and including lethal force, right? So now we have potentially more people armed in public, more people knowing that more people are armed in public, right? And these laws that say, look, if you feel threatened, you can shoot somebody, right? So again, then we get back to who do people think are threats, right? So there's data to show, right, that Black males, again, who are already at a drastically increased risk of gun violence, that they are seen as bigger than they are, older, stronger, more dangerous, more physically intimidating, right? So I want to say then, generally speaking, Black males are at particular risk to be seen as a threat, as a problem, right? And so then even if charges are brought, right? So remember, if we go back to Ahmaud Arbery, the police show up, Ahmaud Arbery is dead, and they let them go, right? It was only later when sort of public outcry happens that they go and arrest them. So there is this element also then of at every level of the criminal justice system, what is seen as reasonable, right? Do the police see your action as reasonable? Yes, you're free to go. No, you get arrested. What about the prosecutors? What charges do they want to bring? And then ultimately, what about the jury, right? Jury of our peers, how are they going to see this action? So the data shows, perhaps not surprisingly, that if it is a white person killing a Black person, it is a drastically more likely outcome that it will be found and seen as reasonable, right? As opposed to if those races and roles are reversed, right? So even, a public health law person, so ideally we would prevent these shootings from happening, but even retroactive sort of justice is really difficult then to come by, right? And so even if we think about that case again of Ahmaud Arbery, what this is saying is, in a lot of respects, it's relatively rare, that outcome, right? So the other problem with Second Amendment and where race and gender and sex come about is the way that racial minorities, in particular Black people and women, are used to justify the expansion of Second Amendment rights. And this also happens in the abortion setting, right? So there's the whole eugenics thing, and that really abortion and birth control was really about controlling the Black population. There's sort of the marketing advertisement that went through and said, the most dangerous place for a Black baby is in their mother's womb, right? All of that stuff. And you have it here too, right? Where even Justice Thomas is saying, well, think about after the Civil War, right? The only way that Black people could really protect themselves is to have firearms, right? And so that's why we should have, right to access them now. And there was all this effort to, to disarm them, right? They also talk about, here again, Alito specifically says, there are these vulnerable groups, including women, right? A woman's being attacked, and thankfully there is somebody, man, right, with a gun to save her, right? And so again, this is why it's important not only to have guns, but again, to have guns in public settings. But in reality, right, how often is sort of like stranger danger the risk, especially to women, right? And what we see is that women are at greatest risk to people that they know, right? Where there's already some established relationship. So the court is using this sort of theoretical lens of stranger danger, women vulnerable out in public and, walking down dark alleys. That's why we need to have guns and self-defense and have them in public. But in reality, right, the greatest risks to women are posed in other settings, right? Where again, it's more likely people that they know, right? And you can see, especially in terms of, intimate partner, family, people that they know. But the other thing to think about is, let's just say, okay, that women start carrying guns around increasingly, and that is actually true. And they start using them to defend themselves, right? So if we think about sexual assaults, for example, right? And the problems that women have with reporting sexual assaults. Well, have you been drinking? Have you been flirting with this person? Did you lead them on? Right? All of these sort of things that end up kind of diminishing their credibility in terms of them being a victim. Well, now, if you're being sexually assaulted and you shoot somebody, right, to defend yourself, it seems unlikely that in that scenario, right, they're going to applaud you for using your Second Amendment right. And so you still have the same types of hurdles and problems. And with intimate partner violence, where there's an established relationship, it actually becomes more problematic, right? So this is, just sort of one example that gets talked about. Marissa Alexander, there's an abusive partner. He comes and confronts her. She has a gun, right? She fires it into the ceiling, not at him, and gets sentenced to 20 years. Ultimately, she doesn't serve the full 20 years, right? You compare that to, the murder of Trayvon Martin, right? Where he says, this small teen, right, attacked me and I had to defend myself. And so again, the ability to exercise the Second Amendment right to defend yourself, it's not as broad as the court tends to talk about it, right? Really what the court then is saying is, you can defend yourself in certain situations. And it just so happens that those situations tend to be more beneficial for white males as opposed to other populations, right? So, okay, well, if you can't, if you have a hard time, defending yourself against your abusive partner, right? What are other mechanisms that you could, that we could pursue to potentially protect these victims, right? And so there is a federal law that says if you are under a domestic violence restraining order, you can't have a firearm. After Bruin, that gets challenged, right? And so this is the Rahimi case. And so after Bruin, right, so this is the district court, first they say, well, Bruin again says, we're not allowed to think about, is this good? Is this bad? Is it effective or not? We've got to go back in history and figure out, did they disarm domestic abusers? Turns out, I'm sure everyone's surprised, they did not actually do that, right? And so the court's like, look, they would take away plenty of other things before they would take away someone's gun. And so Bruin says we cannot find this law to be constitutionally valid because you can't point to a law historically that is similar. Not even one, let alone enough that would be sufficient. So they strike it down, right? And again, the reason this happens is in Bruin, another part of the opinion says, if there's a societal problem that has existed and they don't address it in the same way that you are addressing it now or that the government's addressing it now, it's probably invalid. Again, right, the court says domestic violence has been around forever. So if they weren't taking away people's guns then you must not be able to do it now. I'm not going to go through all this, right, but there's these older gun laws and the government says, here's why they're similar. In the Fifth Circuit, it gets appealed up from the district court. They say they're not valid. But importantly, right, they say, look, we have upheld this law before when it's been brought to us, but we can no longer balance the Second Amendment individual right against the government, what they're doing and why they're doing it, and the benefits of this law. Bruin says we can only look at history. Unfortunately, then we have to strike that down. So part of the outcry for this, right, is perhaps not surprisingly, well, think about the role, right, of women in society around, in the 18th and 19th century, right? They were literal property, right? Marital rape didn't become a crime in every state until 1993. I think North Carolina, I believe, was the last state to make that a crime. So of course, right? And so there's this sort of, forced backwards looking evaluation of, we're using history so much and you're saying history is the thing that matters. Well, who's that going to benefit and who's it not going to benefit? Again, right, white males versus kind of everybody else. But part of the problem that I have sort of had and tried to highlight with this Rahimi case and outcry to it is, the court is forcing us to look backwards, right? If we're saying, look how women were in the 18th century, there's kind of this implicit, and so we're doing so great, right? Because things are so much better now, right? And it sort of hides and obscures kind of the role that, again, marginalized and underserved and minoritized groups play currently, right? And where they fit in. And those things can have an impact still on how these sort of things are evaluated. So again, the Fifth Circuit, right, in a concurrence, Judge Ho, right, you can start to see these are not old historical views on how, civil protective orders may or may not be used. these are current ideas that he has about, well, let's be honest here, women are going to and do use these as a threat, as leverage in divorce proceedings, in trying to get more money and support and custody hearings, right? Even quotes a judge that I just so happen to highlight certain words in there, right? Where it's like, look, your job is not to become concerned about constitutional rights of the defendant you're violating as you grant a restraining order. You throw him out on the street, give him the clothes on his back, and tell him, see you around, right? So clearly, that judge and Judge Ho that is quoting him is seeing this through the lens of this is what women do to men through these sort of protective orders, right? And then ultimately comes up with the really interesting idea that this law that takes away guns is actually empowering and enabling abusers, right? Through potentially mutual protective orders where neither party can have a gun. So then we get to oral argument, right, of the Supreme Court, right? And again, history, it's all about sort of looking backwards. And during oral argument, Justice Alito, again, right, he's great for content, comes up and says, but isn't there really just, a lot of he said, she said in these types of things? Now, if you Google he said, she said, right, again, this is directly linked to, false sexual assault claims, right? Again, women against men and these sort of things. And says, that's a real problem, right? And doesn't this sort of thing happen? Certain general, so General Prelogger, right, who's giving the oral argument for the government, and says, right, this is something we should be worried about, right? And doesn't this sort of thing happen? And she literally just says, like, no, like it just, I don't know the thing that you're referencing, right? This does not happen, right? So, and again, this is not his historical view. This is not his, view of what was happening in the 18th century, right? This is a modern view of what Justice Alito either thinks or is at least concerned about happening, right, with these sort of protective orders. So, part of what you see in, again, the oral argument, but also in the Fifth Circuit is this question of, well, if they're being abused and there's a problem, why would you not just leave, right? Super easy, which again, right, gets into these other things that tell us why people don't necessarily leave. And we're, getting close on time, so I won't go through all of it. But, there are other reasons why, one, they might not leave, or two, why they might want to use a civil protective order as opposed to calling the police and potentially having that person arrested, right? They might need them for money, right? For housing, for healthcare, right? For watching and helping to raise the children, all of these things. So, there's plenty of research and stuff, right, to say, again, why this happens. So, to kind of, again, try to tie all of this back together is we have the court increasing the number of unwanted pregnancies and increasing the number of guns potentially in public, right? Under the guise of these are all protective and good for people, whereas, right, the data is showing that these are not good things in general, right? But especially for pregnant women. So gun violence is a huge problem for pregnant women. It's a huge problem for them directly, but also, again, for the fetus and the child that they want to have. There's even more research, right, coming out about cost to the healthcare system in terms of pregnancies. The other thing, though, is we're kind of, again, establishing these environments where people have problems and then we're criminalizing them for it. So now, right, if we think back to sort of the crack baby era, right, where women were targeted, or Black women were targeted as, you're a bad mom, you are unhealthy, you are a risk, right? And so we're going to arrest you, or we're going to take your child, or sort of force you to do or not do what we want while you're pregnant, right? But there are reasons that they are in that environment, right? They can't necessarily make healthy choices. They, become addicted because of, the environment that they live in. The same thing is happening with gun violence, right? Where Chicago, right? You can see, I mean, it really was just like Chicago thug, right? Or gun violence thug, right? These communities where they're just people shooting and they don't care. So now what do? We either don't care about them, right? And we sort of write them off, or let's police them. Let's sort of militarize that space. And so you can see again then how all of these things tend to overlap. And I'll just sort of try to rush through some of this, right? So really what we need to be doing in terms of both reproductive justice and firearms, right, is thinking about it in a much broader lens, right? So if we're thinking about guns, gun violence, yes, gun safety measures are important. How much of them, how many of them will be allowed after Bruin is unclear. But there are other things, though, that we can do and that we need to do. There's research on green space and climate that impact gun violence. This is, and so thinking about gun violence through a broader justice type framework means let's think about it in all of these other ways, right? So let's make it easier for women to leave abusive relationships. Let's have childcare. Let's have parental leave. Let's have equal pay, right? Let's have livable wages so that people are able to leave areas where gun violence occurs, right? As opposed to feeling stuck there. This is another thing where Rush in Chicago, right? They're trying to find ways to invest in their community in particular, right? So this is just one example that I try to use. This is, again, going back to 1905, right? The way that we think about self-defense and the way that the court talks about it is, again, through a very individual rights-based lens, as opposed to the communal aspect of how do we think about rights. If we're talking about gun violence being a problem, right, especially in a public setting, who are going to be the people that now feel like, I'm not sure I should go to the grocery store or the movies or a concert or a sporting event or whatever, right? So freedoms and liberties will be impacted, but you don't see that if you're just thinking about, here's this individual that wants to carry a gun, and that's what we're focused on, their right. And so to be more scary, right, there's a bunch of other things that could potentially be coming up the works, right, in terms of, because one thing that Bruin says is, well, history doesn't matter for what is protected by the Second Amendment. That gets updated, right, for anything that can be used for self-defense. So when we're thinking about, reproductive justice, I really think that it's useful to think about firearms in the same way, right? So Loretta Ross says, when it comes to reproductive justice, if you're starting at pregnancy, you're starting in the wrong place. I think if we're starting at gun deaths, right, or gun violence that is already happening, we're also starting at the wrong place. And I think as terrible as Bruin and Dobbs are, in terms of public health outcomes, but also in terms of constitutional jurisprudence, they do offer opportunities to take wider lenses and how we think about both reproductive justice, but also firearms through a firearms justice framework. So thank you, everybody.
Thank you so much, Professor Ulrich. That was great and really informative. I will let other people ask questions, but I just thought I'd start as moderator's privilege. So first, I just wanted to say I was really captivated by the way you described sort of access to the individual right versus public health burden, and how like white men benefit in both areas, right? They have more access to the right that they're protecting and are also less likely to carry the public health burden. Yeah. And I don't have a question about that, but I've been thinking about this a long time and I'd never thought about it that way. So that was really helpful. The other question I wanted to ask you though is, so you put the quotes up from like Alito et al. And they're saying, well, we read about this woman in Tennessee once, right? But then you're putting all this data on the screen, which theoretically the Supreme Court also had access to. And I know the court system has a fraught relationship with science. So could you tell us a little bit more about why the courts are not citing empirical data in their opinions when they're making these big public health decisions?
Yeah, I mean, I think there's a couple things happening. One is judges, but especially Supreme Court justices, they don't want their job being done by somebody else, right? So you come with all this data, say, this is a good law, it's valid because it has this great impact. They're like, hold on, don't tell us how to do our job. So I think that that's an issue. But I think, again, between Heller and Bruin, for the most part, lower courts were looking at data and they were like, so these laws are valid. And so the use of history here says, it just so conveniently says, oh, that stuff doesn't matter anymore, actually, right? And so it takes that away. The other thing that I think is happening here is, and I think I can sort of understand it to some extent. You have somebody that comes in and says, all of these other people have done bad things with their right, with their right to a gun. Why should that impact me, right? It's my constitutional right, and you're telling me that I can't exercise it because of other people doing bad things. I mean, I can understand sort of like the rhetorical force of that, but when you just look at that and that alone, I think that's what the court is doing, because then it helps again to obscure sort of that other stuff, especially when you're using the like, well, bad people do bad things and good people only do good things lens. Yeah.
Other people have questions? Yeah, you can just say it and maybe you can repeat it, Michael, for the people on Zoom.
Sure. Yeah. Yeah, so the question is about the use of history and other sort of constitutional right aspects. I mean, history is used, right? So when we think about the First Amendment speech rights, right? The court uses history to think about, well, what are the principles and the values? Why do we have a right to free speech? Why is speech protected? It's to, you know, sort of get ideas and for us to learn and for the government not to enforce things on us. So what does that tell us about internet regulation, right? So, but that's different than what speech laws existed in the 18th century. That's all you can do today, right? And so it's really the use of history to this extent, especially for the Second Amendment. I don't think that there is another right that, you know, to me, and I know there are plenty of other scholars that agree, it's put on a pedestal is really what it is. I mean, again, history is used by all of them, but how it's used, I think, differs. And you know, the more conservative justices, even they don't always use it the same way between each other, but even they don't use it the same way themselves, again, depending on the right, the issue, and things like that. So there isn't a consistency, and that's what makes it really fun, but tough to teach constitutional law to students. Yeah. So originalism is certainly a part, and the theory behind originalism is whether it's a constitutional amendment, right, or right, or a statute. We don't want judges saying, well, here's what I think. I think speech means this, but not this. And then, you know, they retire and then someone else comes on and says, well, I think differently, right? And so it's supposed to be, when this was passed, what did they think it meant? But again, the idea is supposed to be more like in terms of principles and values. And again, other people that focus and are much more, you know, greater experts than I am in this space go through and they're like, well, here's Justice Scalia, right? The, you know, biggest proponent of originalism and textualism. And here are the places he uses it, and here are the places that he doesn't, right? But the idea theoretically is supposed to be to limit the amount that judges and justices can sort of use their preferences, ideology, opinions, right? That they are restrained by what has already happened. But in reality, it just doesn't actually play out that way. And again, part of it is also it hides this like, we are being objective. This isn't what I want or think is good or, you know, whatever. It's just, those are the words. And that's all that we can do. I mean, if you want to listen to the bump stock oral argument, it'll drive you insane because it's really just talking about like 3 words for about an hour and a half, basically.
Great, thank you. Wait, one more. We have like a minute, 30 seconds. But so Rahimi is the new court case that the court is going to decide that went through oral arguments and we're going to get the decision in June. what's going to happen?
Yeah, so the oral argument, it seems like the court is really not excited about returning or saying this person who I think he had 5 shootings in the span of like 6 weeks, shot into people's houses, into cars, shot at a police officer. I don't think they really want to say that he can have a gun. I haven't seen anybody who's figured out how they're going to uphold the law and say that Bruin is still totally fine. So the question is going to be, yeah, how do they do that? Because there also, it seems clear that there are justices that want to leave open the challenge for other felons, right? I was convicted of a non-violent felony. Am I really not going to be able to have a gun for the rest of my life? I think they want to probably strike that down, at least some of them do. And so they're gonna have to find a way to say, this is valid, but these other things that may come up in the future are not. But I don't know how. But most people think that they'll uphold the law.